Okay. Okay, I think that, can you see that? Everyone can see that? Perfect. I'm gonna get rid of my video then here.
All right, thank you for that kind introduction, April. So without further ado, we're gonna get going this morning. We do have a lot of material to cover. I just wanna say that at first, I hope everybody's doing okay out there, that people are healthy and safe and their families and friends are doing well. I know these are definitely difficult, trying times. I guess that didn't stop the Colorado General Assembly from adopting a lot of new laws this year. So if we could just go to the first slide, please. One thing I'd just say, if you have questions, please ask them. You know, we had a little discussion about that. If we get a ton of questions, I'll probably hold them to the breaks in between topics. But I guess if there's just, I have no idea how many people are on, but if there's just a couple of questions here and there, I will probably answer them as we go. So let's just kind of signpost or outline today's presentation. We're going to deal with the Colorado new laws, the non-COVID related laws, and then we're going to talk about some COVID related issues, including the CARES Act and what we consider to be other hot topics and issues. Next. So the first new law that came into play, and I'm sure people have heard a lot about this over the last, I don't know, I guess several years, because it's come up couple times at the General Assembly, I think last year and maybe even the year before, and actually Boulder and Denver enacted source of income laws, but this finally became a law on the state level when it was enacted. And as you can see, it prohibits discrimination based on source of income, amended the Colorado State Fair Housing Act. So in general, when people talk about fair housing laws, they talk about protected classes. Well, this legislation had the impact of making source of income is now a protected class. Next slide, please. So, and really what this means is you can't discriminate against any applicant based on where they're getting their source of funds. And, you know, key definition is it means any lawful and verifiable source of money that a person is entitled to or paid directly or indirectly to them. Obviously, you know, it's any money they earn, but, you know, also money could come from a lot of different sources, income or rental payments derived from a government or private assistance program. So obviously that starts to, you know, that gets at the thrust or the main purpose of the legislation, which was to make sure that landlords did not discriminate against applicants or tenants that were on governmental assisted payments like the Section 8 program. One of the things that, you know, I'm sure everybody knows that I'm significantly involved in lobbying and legislation. And while this bill was being discussed, one of the most significant concerns was the fact that, you know, people would just come with some kind of pie in the sky, and then we were able to get that part in about variable source of money paid. So they can't just come in, and I don't know how, let me just put it this way. Back when in the housing crisis in 2008, they literally had this product called stated income, and you didn't have to even prove that you made the money, you just stated, you know, I make $1 million a year. So luckily we were able to get that put in there. Next slide, please. So the key is, you know, and this is really kind of what it's all about, is that landlords cannot refuse to rent or make housing unavailable because of a person's source of income. And this means that you have to accept Section 8 housing choice vouchers, whether you want to or not. And let's just start off with some kind of key points that you need to be aware of. The first thing is you need to be aware of this law in the sense that people might come in, and everybody's used to, hey, well, give me, your last 4 or 5 or 6 pay stubs, maybe a bank statement, things like that, of that nature. But you have to be aware under this law, they could come in with something else. So you just can't say, hey, no, we don't accept it. This is our process. So you have to be aware of the fact that this is the law. And if somebody comes in with an unusual source of income, you have to at least evaluate it before you say no. So, it's kind of equivalent to, a reasonable accommodation request under the fair housing laws. You don't have to grant every accommodation, but you never just say no automatically without fully evaluating the situation and make sure that you have a clear understanding of the facts. So, and obviously you can't just say no Section 8 or refuse to show a unit based on that. The other part that is you can't discriminate in the terms, conditions, and privileges of housing based on someone's a source of income. So people always ask me, and we talk a lot about this in our fair housing classes over the year, because the expression terms, conditions, and privileges is really ensconced or ingrained into the fair housing lexicon. And so people really ask me, well, what does it mean, Mark? Well, it means anything and everything. If you think about it, the expression terms, conditions, and privileges is such a broad expression that it literally covers everything. So anything about the process, the application process, the welcome process, the vetting process, the resident policies, the community policies, while somebody's in, is you can't treat that person differently based on their source of income. The other thing too is that they've adopted some of the other expressions from both the federal and Colorado Fair Housing Act, which says, it would be illegal discrimination for any person to make, print, or publish, or cause to be made, printed, or published any notice or advertisement relating to the rental or lease of any housing that indicates any limitation or discrimination based on a person's source of income. And so it's really important that everybody is really, knows, like, look, you can't even, okay, say it's company policy, to, abide by the law, and which I hope it is. And I realize that's why everybody's on this webinar today, is to learn what their new legal obligations are. So it says, okay, we realize we have to take Section 8 housing, but maybe somebody on the ground, on the on-site team, doesn't get the memo, and somebody comes in and they say, oh, well, we don't take Section 8. Well, that's a violation. And people, I remember one time a client said to me, they got in trouble for putting out a notice to the community, kind of like a little flyer, because there was, a couple accidents on the property involving children skateboarding and doing something like this. And so they put something out that the children couldn't play in certain areas, and, which is a violation of the Fair Housing Act, which I'm not going to get into. But so the takeaway is that the client said, well, Mark, that's not our policy. That's not our policy. Well, it doesn't matter if it's your policy or not. If you make or publish, and publish means to write down or put out, or just basically to verbally express. If you tell something, tell a person, a tenant, look, like, we don't take Section 8, you've just published that statement. So that would be a violation of the act. So it's important to know that you can't, in your printed advertisements, state that you don't take Section 8. But it's also important that everybody gets on the same page, that you can't even make verbal statements to that effect, or any statement that would kind of give somebody the impression that you are limiting or otherwise refusing to rent based on their source of income status. And obviously this means you can't advertise no vouchers. For those properties in Boulder and Denver, and I don't know if we have any clients on that have assets in those counties or communities, this isn't a big change, because that's been, I don't know the exact, I mean, they passed so many ordinances. I know it's been in place for, I'd say, at least 2 years, maybe longer. The older you get, the faster time goes by. But the other important thing to know about this law is, and I'll give it up for the General Assembly, they've gotten very good at that, is because they always define landlord very broadly. So that always means that it includes owners and managers. So everybody is responsible for both compliance, and they're also liable for violations. So let's go to the next slide, please. So the new source of income law applies to all rentals unless you're exempted. So the exemptions, I think, are pretty are pretty straightforward. Is if you just have your landlord and you got three or less total units, then you're exempt. So if you're kind of like your mom and pop operation and you have one or two, as a retirement investment vehicle, or you're trying to save money for your kids' college or something, then this would not apply to you. Now, if you have 5 units, you can refuse vouchers, okay, but only on your single family unit. So let's just talk about that for a second. So let's say you got 5 units and 2 of them are single family, and say 3 of them are, in townhomes or condominiums. Well, you could only refuse vouchers on the 2 single family units. You couldn't refuse vouchers on the 3 rentals that were located in a condominium or townhome, development. The other thing, if you have 5 single family homes, you could exempt all of them from vouchers. But the key point about the 5 or fewer exemption is it only applies to vouchers. So there are other sources of income that you would still have to review and exempt. So don't get into the mindset, if you're exempt, say, hey, we're out, we're totally exempt on the 5 or fewer. That only applies to the 3 or fewer. So if you're in the 5 or fewer boat, you still would have to evaluate the source of income if it was a non-voucher source of income. Sometimes I really am wary of exemptions because, folks tend to think it's a total safe harbor, and sometimes it's not. The other thing is the Boulder and Denver restrictions are not as, the exemptions rather, are not as generous. So if you're in those jurisdictions, you would have to go by what those local ordinances are. And if you have questions about that, I would just contact the situation board. Next slide, please. So it doesn't, before everybody gets all upset, it doesn't prevent you from, running, a credit check, but, you have to do it for every tenant. And I would hope that, that everybody is being consistent, and because if you're not, regardless of this law, if you're not being consistent during your application process, you're already maybe violating fair housing laws, because you just want to treat everybody the same during the application process. And, obviously this means that you couldn't, subject, Section 8 voucher holders to tighter screening processes. So let's just kind of talk about probably the number one question that we get asked about this source of income law vis-a-vis credit screening standards. And that is, well, Mark, we, standard industry standard, or, at least a benchmark, and, I think most people use this, is that they have to have 3 times the amount of income as the rent. So if the rent's $1,000, they have to make, for example, $3,000 a month. but we don't recommend that on vouchers is, you know, because remember the way vouchers work is the rent, the tenant is being subsidized by the government program, the voucher program. So going back to our example, you know, if the rent was $1,000, but the tenant's portion, you know, of that rent was $200. So in other words, the government is subsidizing $800 of the monthly rent, then we would recommend 3 times 200 at 600. I think you're just asking for trouble if you're going to try to screen out voucher holders based on the 3 times income level, because the whole point is to give them a shot. Now, one of the things, now that it's a state law, and I don't know the exact numbers, and I'm sure somebody could look into it, but there just are only so many vouchers to go around. So I don't know if people are going to be inundated with you know, voucher applicants. Maybe, I don't know, maybe, so let's just talk about that. So I think the last time they had a lottery for, you know, a number of slots, literally thousands and thousands of people tried to get them. You may see a phenomenon of current voucher holders trying to relocate or move to what they perceive to be better living conditions. I don't know. We're just going to have to see how it plays out. Let me see if I have another note about that. So I guess that's what I have on the new source of income law. So maybe if people have questions, we could take those at this time.
I'm not seeing any questions right now, Mark. I think you're good.
Thank you. Have you guys had your coffee? Are you guys asleep?
You're just explaining it so well for us.
Well, thank you. I just usually we just get a ton of questions. So I don't know. I guess when Vic and I have been doing our webinars, I guess when you have one time we had almost 1,000 people on, we're like, hey, hold the questions. Okay, so I guess we're ready for the next slide. So this we're turning the page here to the next new law, and this is House Bill 20224, the Immigrant Tenant Protection Act, or I call it the ITPA. This is something you really need to be up to speed on this, and because number one, it's a new law. So and it applies to every single rental, no matter what. There are absolutely no exceptions. So that's important to know. It's a little confusing, and if people, I don't know if they've actually read the law or not. I don't know if you're law geeks and you go on and get the bill from the General Assembly website or something like that. But, you know, there was some discussion, well, in the safety clause, you know, and that's a very, you know, for, you know, kind of inside geeky legislative terms, the safety clause is always the portion at the very end of the bill, which really deals with when the bill is going to go into effect. So there is a little bit of confusion about this particular piece of legislation, because the safety clause says that it goes into effect immediately, but then within the bill itself, it says that it's not effective till January 1st, 2021. So I think it's clear that that is the date that you can rely on, even though there is a contradiction in the effective date. So I wanted to bring that up just in case people did actually read the legislation itself. So that's kind of the drop dead date when everybody has to have their act together. So let's go to the next slide, please. So the purpose of the law is really simple. It is to prohibit discrimination based on a tenant's, and actually the slide should say, and I don't know if Matt's on, Matt, but if you're on, please edit that slide in the future. It should say a tenant's immigration or citizenship status. Okay, so really, if you look at it, well, what's an immigration status? I mean, I don't know. I would just say generally with broad strokes, there are three kinds of immigrant statuses. Well, I guess maybe. Well, I guess if you're a citizen, then you have you don't have a status, but you're either in the country legally or you're in the country illegally. Those are really the immigrant statuses. And then the citizenship status is really bifurcated. You're either a United States citizen or you're not. Now, this bill was, people, I'm not going to get into the whole, political arguments on both sides, but I would just say that clearly the purpose or the bill was enacted by sanctuary city advocates to shield illegal immigrants from deportation. I mean, that's the whole purpose of the bill. And there's there's a lot of litigation on this issue nationwide, and the legal fight really centers on whether this type of legislation constitutes illegal harboring in violation, illegal harboring of illegal immigrants based on the federal immigration statutes. So that's the issue where the legal battles are being fought, is whether it's a violation of federal law. And the other issue really is the legal precedent, I think, is pretty clear in the sense that immigration is a federal issue. And so the other point is whether states have the right to legislate in this area at all due to the federal preemption doctrine. Just explain that in layman's terms. That is if the federal government has, here's a state, here's a federal government. If they've, legislated in an area, generally the federal law preempts state law. But here's the bottom line. And then again, regardless of what your position or politics is, until it is successfully challenged in a court, whether in state or federal court, it is the law in the state of Colorado. And that means everybody needs to comply 100%. Because I'll tell you this, the impetus, and this is not an exaggeration, the impetus and the genesis and the driving force behind this law was an attorney firm that literally wants to bring endless litigation against the rental industry for violation of this law. So everybody needs to pay attention and run a tight ship on this because they're going to be looking for violations. Next slide, please. So as I said before, this applies to all rentals. Now, based on the definitions in the law, there's no dispute to this. So there's no exemptions. There's no, this doesn't apply to me. Every landlord has to comply with this law. Next slide, please. So we're going to talk about, we talked about immigration and citizenship status, and this is important too, because to take a quick look at this definition, because it's the person's actual status or their perceived status. So say somebody, and what that means, they're like, well, Mark, why is that important? So why it's important is because even if somebody is a United States citizen, or even if somebody is in the country legally on a legal visa or green card, if they could allege that you discriminated against them under this law because you perceived that they weren't legal or here. And that's really, and I know why that's in there. And what it does is it just broadens the potential liability, or opens the door even more for people to make assertions or allegations that they were discriminated you know, based on this. And I know why it's in here, and my associate Karen knows why it's in here, is because, you know, the attorney that was, you know, trying to ask for some pie in the sky number over this, you know, her client, I was a naturalized U.S. citizen. That, you know, that means they started out somewhere else and they were, you know, were awarded or, you know, achieved United States citizenship. And they said, well, they were treating him like, you know, he was an illegal immigrant. So that's important for folks to know, that you can't put out that vibe, you know, like that you perceive somebody to not be a citizen or to be in the country illegally. Next slide, please. Again, all of these, I will say a lot of these laws are very poorly written. I don't know if people have heard me literally be up on my soapbox preaching endlessly about how poorly they revised the Warranty of Habitability Act. But the one thing I'll give it up to them on is they do a good job on casting this wide net on what a landlord is. And, you know, it's the owner, manager, or lessor. So that means, you know, third-party fee managers, you're on the hook, both for compliance and responsibility. And you just can't just push that off to the owner. Next slide, please. So I think the rental agreement, you know, means what, you know, most people think. But the important thing about this is, and believe it or not, there's still, you know, and I don't think it's a fair number, you know, it's not like a significant number in total, in like total units, but, you know, it's significant in the fact that it exists. Is, you know, we have clients and there are other landlords out there that just have the kind of the handshake, hey, the rent's $500 a month, and, you know, it's over when I say, you know, so it's an oral lease. So you can't get around this based on saying, hey, well, we don't have you know, a written agreement. And we'll see a little bit down the road here, I don't know how many slides, why that's important and kind of why they wanted that to apply to verbal agreements. So next slide, please. So you know, obviously I think this would come up more in dealing with prospects than with actual tenants, but tenant means both prospects and current tenants that you are renting to. So you know, the key point here is, and I think this is where, you know, the battle is going to be fought on this, and where the lawyers are going to try to establish liability, is that they're going to contend that you violated the law by asking impermissible questions during, you know, during the application process. So it's, you know, the key part about that is it's very important to have a standard, you know, process that's followed every time, where you can say, look, this is our process. So that couldn't have never come up, because they're going to try to, you know, say people brought it up. Now, the other thing too is that I wouldn't put it beyond, and I don't know, I really want to have faith in my fellow man, but I wouldn't put it beyond lawyers, and particularly the lawyer that's responsible for this bill, to send people out like on fishing expeditions, where they send prospects out into the wild, meaning into the application process, trying to trip you know, people up. You know, they might even be as bold to say, well, do you rent to illegals and things of that nature. So you have to really be aware of that, because that's really what they do to enforce the fair housing laws, is they send out testers. I could definitely see this attorney sending people out try to establish liability on that basis. You know, it's kind of funny. I'm going to divert for just a minute. Is I let my crew know yesterday I came across a class action lawsuit against the makers of Mike and Ike's and hot tamales because they said that the box, there was too much empty space in the box, and that was deceptive. So if lawyers are going to sue over that, they'll sue over anything. So you have to be aware of the fact that people might come and try to trip you out of this. By the way, just as an aside, I love Mike and Ike, so apparently I'm entitled to 8 free boxes. Next slide, please. So this is important to know, is a lot of times, you know, clients, yeah, I know, it's funny, but there's a limit of 8, and I'm like, well, I bought much more, many more boxes than that during the period, but I guess it's 8, but I don't need a proof of purchase. I'm probably going to call the lawyer up or send him a note and say, you got to be kidding me that you would bring a lawsuit over something like this. But clients always ask us, well, you know, can we get around this, or, you know, can we put something into our lease? And the answer is no. Any attempt to circumvent the act is void. You know, and similar, and I think people are really familiar with this concept from the security deposit law, is you can't get around the legal requirements that you have to give a disposition statement and a refund in the time frame prescribed by the law, and you can't get around that based on something, some provision that you put in your lease. Okay, next slide, please. Now, the easiest way to look at the ITPA is you just look at it this way: what we can't do and what we can do. And so we've already talked a fair amount about what you can't do, but we'll continue along that line now on the next slide. So this is kind of the money, the real heart, if you will, of the law on this slide. So you might want to mark it for future reference, but you can't demand, request, or collect information relating to their status, and that's just the kind of the bottom line. So remember, it's a violation if it's a perceived violation. So got to really run a tight shop. But the thing that's interesting is that if you're a landlord, or if you're an employer, you may collect information required to complete employment forms required by state or federal law. This isn't really my bailiwick, but I guess I know enough about it that, you know, maybe people are making sure that people are here legally on the E-Verify system or something like that, which, if you really think about it, it's really, overall, it's ridiculous. So, and the reason I say that is because if you're going to employ somebody, you're going to ask about their citizenship or immigration status pursuant to the E-Verify program, as I said. And, you know, the E-Verify program requires the employer to complete an I-9 form. And on the I-9 form, it asks citizenship or immigration status by checking the appropriate box to indicate whether the employee applicant is a U.S. citizen, a non-U.S. citizen, national, a lawful permanent resident of the U.S., or an alien authorized to work in the U.S. So if somebody doesn't meet, you know, can't say they meet any of those statuses, then, you know, they're not qualified to work in the United States. So if their person is in the country illegally, obviously they can't check any of those boxes. So, but under the new Colorado law, you can't ask this. So you couldn't use this information to deny the tenant applicant, even though you know that they're in the country illegally. So it's just absurd in my opinion. Now, this is a critical point on this to be careful about, is make sure you don't have any written records or email about a person's immigration status or citizenship status, because if you get sued, that's the first thing they're going to ask for. So it's not enough just to not ask them or perceive that under the law. You can't have these sidebar conversations internally and say, well, you know, I'm kind of concerned about whether they're going to remain in the country the entire lease period or something. Something like, don't do that, because that's gonna be the first thing that they're going to ask for. So don't have any records of that effect. Next slide, please. So you remember, these are all mandatory when a statute, and that's from the statute, says a landlord shall not, and then disclose or threaten to disclose information about the person's immigration or citizenship status. Again, clearly, you know, based on this is really kind of a sanctuary city type policy. And again, I think it just puts people in a really bad position in terms of this, is you're not supposed to know about their status because you're not allowed to ask. But if you do somehow know, you're required to break the law if asked, because, you know, potentially break the law if asked, because federal law may require you to disclose that status. But then even more perplexing and contradictory, later on in the statute under the ITPA, that's the Colorado law, it allows you to otherwise you know, disclose, or you're not otherwise prohibited from complying with any law, including federal law. So it's crazy in my opinion. It's totally contradictory. So here's what we're advising our clients: is the best mode of operation is just remain silent until legally compelled, or you have an opportunity to consult or speak with legal counsel. Obviously, you know, this provision in this law is an attempt to make all Coloradans follow a sanctuary state policy. I mean, here, I don't care where people are at on this, but the bottom line for me is things need to get resolved at the federal level, and citizens, including landlords, shouldn't be left in legal limbo. So whatever the result, and however they do it, Congress needs to step it up and resolve these immigration law issues once and for all. It's just crazy that you're put in this position, but based on this law and federal law, I really would just mum's the word until compelled, or until, you know, you can consult with us about it. Next slide, please. Obviously, you couldn't refuse to enter into a rental agreement based on somebody's immigration or citizenship status. So what this means is really simple. So if for some reason you actually know a prospective tenant's immigration or citizenship status, you know, say, you know, for example, somebody's in the country illegally, you can't refuse to rent to them on that basis. That's really what this means. Next slide, please. Okay, and also you can't harass or intimidate or retaliate for exercising their rights under the ITPA or any conduct prohibited by the IPTA. This one is a little bit perplexing to me because the tenants or the prospective tenants really don't have any rights. The thrust of the statute is a proscription or limitation on landlords, and that is that landlords are prohibited from asking about immigration or citizenship status. So I'm not really clear on what rights a tenant could exercise. I suppose the tenants could oppose if a landlord asked about the citizenship or immigration status. A tenant could oppose a landlord's efforts to ascertain their status. But again, that doesn't really make a lot of sense, because if the landlord does that, then they've already violated the statute. So I'm not sure why you need this additional limitation set forth in the statute. But the best thing, I guess, is just to say we're not allowed, if it comes up, we're not allowed to discuss, inquire, or know about that. Next slide, please. So you can't interfere with the tenant's rights to occupy a rental, based on their status. Then I guess, it takes it further in there. That means really kind of what it means is you can't attempt to, say, hey, I know, you got a problem with your status, so you need to surrender possession of your unit. That would be illegal under the statute. You can't discourage somebody from seeking to rent from you based in whole or on part on their immigration or citizenship status at all. So the bottom line is this is just really a non-factor. Immigration status or citizenship status based on this statute should be really a non-factor in the process. Let's go to the next slide, please. This one's really perplexing to me. That you can't evict based solely or in part on the immigration or citizenship status of a tenant. And the real reason why this is so perplexing to me is apparently the Colorado General Assembly doesn't know that this would clearly already be illegal, both under the Federal Fair Housing Act and the Colorado Fair Housing Act. So I don't know, I'm kind of torn, because on the one hand, I think there should be a prohibition on lawyers being in the legislature. But on the other hand, obviously, when you don't know the law, you just keep making additional laws that are already covered by the law. So we've had a long discussion, or somewhat significant discussion, about what landlords can't do under the ITPA. So let's talk about what landlords can do under the ITPA. Next slide, please. That's what we're going to talk about. Okay. And so this is where, as I alluded to earlier, it gets a little bit problematic or tricky because they said, hey, you can't disclose, mum's the word, shh, but it doesn't prohibit you from complying with legal obligations under federal, state, or local law. Next slide, please. So, including any legal obligation under a government program or pursuant to a condition of government funding. And this is really, to me, just illustrates the hypocrisy of it all. Under the Section 8 program, the voucher program. And, you know, it's ironic. They just said, hey, you got to take vouchers in the source of income law we just talked about. But under the Section 8 voucher law, the assistance is only available to U.S. citizens, non-citizens with legal immigration status. And, you know, so it's kind of like, hey, we can ask about somebody's immigration status, but you can't. So it's just really, really hypocritical, in my opinion, when the federal government can ask about immigration status, but Colorado passes a law that says you can't. And then, you know, it just has kind of become problematic, you know, with, you know, because then they're encouraging landlords rather to take Section 8, not encouraging it, mandating it. So let's go to the next slide. This would include, you know, you can't, you know, the law doesn't prevent landlords from complying with, you know, subpoenas, arrest warrants, or any other court order of any kind. So I don't know, I could see some stuff going wrong on that where the landlord in good faith complies with that. And then they're saying, well, you're inquiring or you're disclosing, or, you know, if you think about it, if you complied with, say, for example, a subpoena from ICE or, you know, some other governmental agency and produced records, you know, you would be immune or safe under this provision. But then they might say, well, oh, well, you disclosed it to somebody else. Is, you know, I said, you know, told you 302s in the country illegally, and, you know, pursuant to that, you know, subpoena, now you've disclosed it to somebody else. So even if you lawfully complied with lawful government dictates, you still would need to be careful that you don't disclose beyond that, because I could see that becoming an issue as well. Let's go to the next slide. So it also doesn't prevent you from screening tenants to determine financial qualifications. And on the one hand, I just have been really going back and forth on this. On the one hand, I think I was like, well, you know, it's pretty good because it says, you know, you can ask for social securities and TINs, tax ID numbers. So I was saying to myself, well, so does this mean that if they don't have one of these, you can deny them from renting? I mean, that's kind of the way, you know, I read it, but I can also see, you know, the people arguing and says, well, that's a pretext, you know, for denying them. And the real reason is you denied them based on their immigration status because they don't have a social or a TIN. We'll have to see how that plays out. I do think it's very clear that landlords do have a legitimate non-discriminatory business reason for asking for this information. You know, we collect, you know, money. You know, Vic and I are owners in R.D. Fuller. We collect it nationwide. You will not collect money if people do not have a social. I mean, it's just, that's the reality of the situation. I don't know how many people are showing up with TINs. You know, I think probably the safest, most conservative policy would be certainly to allow either. That's always been an ongoing debate, whether you can require a social. It's probably beyond the scope of this presentation, but I think you would have a very strong argument if somebody brought some, you know, a suit against you based on this law. If you said, well, we asked for a social or a TIN, is either one is you know, acceptable to us. So you know, the key point here is you have to be just really diligent and consistent about your application process, and always request the same information or documentation of all applicants, regardless of immigration or citizenship status. Now, there was a problem. I don't know how many folks on today's webinar, you know, you use the Blue Moon, or it's called Click and Lease now, the NAA lease product. There was a little problem with the non-US citizen applicant. Karen fixed that. So, and that should be available well before, I think it's probably already available, but it should be well available prior to January 1st, 2021. If you're not being consistent during your application process, you're already probably violating the fair housing law. This is one of the things that this comes up a lot with, is with smaller owners, or what I should say, management companies that do third-party fee management for smaller single family owners. And, you know, that's, you know, people that might have the 5 or less or 3 or less single family units that don't want to deal with them. So they hire a competent third-party fee manager, and they start giving the third-party fee manager, well, they want to see the applicants, and they want to pick the winners and losers, and they want to, you know, say who's most qualified. You can't do that. I mean, I just cringe when I hear these stories, and it's like FIFO, F-I-F-O, FIFO, I guess you could say FIFO, is an accounting principle, first in, first out, for governing a court inventory. So it's the same with applicants. You have to rent, you have to stack them in a line. Like, just think of them, airplanes coming in on a landing pattern. The first plane the land is the one you have to rent to, you know, because it successfully landed, you know, which is an analogy that you have to always rent to the first qualified applicant. And you can't, because if you have like 5 applicants, and, you know, you got 2 of them have issues with citizenship or immigration status, and you rent to somebody else, boy, they're going to say that would be a big problem. So I don't know if we have a question. It looks like we might have. Do we have a question, April, in the Q&A?
So I did get one. It's a comment. It says NAA is going to stop making the supplemental application for non-citizens available in Colorado. It's not going to be revised.
I'm not sure I'm following you on that, because I know it was revised because we revised it. So I'm not sure if they've released it yet, and I don't know. I could try to ping Karen and see when that's going to come out. But they did revise it because some of the you know, that was challenged before, and I thought it was a groundless challenge, but it was challenged before this law even came out. So I know it's going to be changed. So I don't know. I'm not clear on what the person is referring to.
It looks like that's the only question that I saw right now.
Okay. You guys are sure not a very inquisitive bunch. It's like, so, all right. So we talked about that. So let's go to really what this is all about. And it's really all about the lawyers. And I'd say without hesitation, this particular lawyer cashing in on this, because really here's what, you know, what they're looking for is you get money. You know, they can say, hey, I've been injured or damaged in this way. It's a minimum of $2,000 per violation. Of course, they want to have you pay their attorney's fees and costs, and any other equitable relief that you know, the court may deem appropriate. I can tell you that's really was the drive. In my opinion, the person can say that you know, oh, you know, that we're really doing this for humanitarian, or, you know, for the good of you know, immigrants. But to me, based just sheerly on the amount of money that was asked for in these lawsuits. I mean, literally hundreds of thousands of dollars over something that was maybe should have been like a $2,000, claim. It's really about the money. So people, again, I just wanted people, I'm not trying to, scare everybody, but I'm telling you, these attorneys will sue over this. So if you're not prepared, you're gonna get sued on this, and it's an automatic $2,000, even if they can't prove any damages. Well, if you did it 20 times, that's 40,000. And then, then the way that goes is they'll say, well, we got 20 violations, that's $40,000. And, if this doesn't settle, there'll be, $100,000 or $200,000 in attorney's fees. So we'll settle for $125,000. That's the way this is going to go down if you're caught violating. So I guess I'll be on official record saying that, because this webinar is being recorded, and we certainly don't want anybody to be in that predicament. So I'm going to move on unless we have any questions. I will say maybe Matt will send out a Starbucks gift card, even though I really am not a big Starbucks fan, to the person that asked the first legitimate question during today's presentation. Hey, but how many people do we have on?
Right now, sorry, let me get to it. We have 22.
Okay. Well, maybe we just don't have enough people on to do that. So we're moving on. We've got another half hour, so I think I can get through the rest of this. So this is important to know too, is the ITPA overrides jury waivers and leases, of course. So they, want, the juries, threaten you, the jury's going to award $1 gazillion against you if you're not down with the program. So that's important. Even almost all leases have jury waivers in them. So if you have a good lease, if you have a bad lease, then you don't. But that just is a clause that says, hey, no matter what happens, and if you sue me or we sue you over a breach of the lease, both parties waive the right to a jury, and that the case has to be heard by the court. Now, the reason, jury waivers are put in is really, jury is a cost thing. And, it's just much more expensive to try a case to a jury than to a judge. So I guess since we don't have any further questions, I'm gonna move on to something that's a little less heavy. Okay. Did we go? Did we go backwards in the presentation, or was that the next slide? Okay, yeah, let's go.
I think so. I think I just hit it once. I don't think I must.
Let's go forward. Okay, I don't know if Matt had that in there. Let's go forward again, please, April. Okay, there we go. Okay, so Matt, if you're on, you need to remove that slide. I think that's okay. Let's go back. I messed up on that. We need to go back one slide. It just kind of threw me. So the other point that's kind of ridiculous is you can't ask about status. You're not supposed to know. But if you get sued because supposedly you violated the law by disclosing or asking about the status, and then that the lawsuit is really about liability over the immigrant's status, the ITPA says it's irrelevant in any suit to enforce it. So I've never seen anything like that in any law. I guess you could bring it up. I think that, I don't know, I guess my original thinking is they want the jury to, they want a jury trial because they're thinking the jury's going to award them big bucks. But then in front of the jury, they don't want to bring up that the person might be in the country illegally because they think that would hurt their chances of being awarded money. So I don't know. That's my only take on that. So without further questions, we're going to move on to something a little bit easier to get our head around, and I guess is not as heavy. They passed a law that limited certain debt collection actions, mainly, as we're going to see, and probably for the next 8 or so months, but well, I guess it's probably less than that now. Next slide, please. Really, why do you need to know about this law? It's not a huge thing, but you need to know that if you collect money from your tenants using a legal process, and that means through lawsuits, you use the courts instead of just a collection agency, and just kind of an FYI for everybody, you're always going to collect more money on your write-offs or your past due accounts if you do deploy a legal process. You probably want a collection agency process, and a legal process is really ideal than if you just send them to a collection agency. And the reason for that is simple: is that, the guys at the collection agency call and they write letters. Well, people just say, I'm not paying, then they put it on their credit, and that's the end of it. Where with the legal process, they actually get a judgment in court, and then can use the legal process to compel payment. So we'll talk about what those processes are. So if you could forward to the next slide, please. So the legal process for collecting from tenants includes garnishment, attachment, levy, and execution. Really, people can, people still do attachment, levy, and execution, but really I'd say about 98% of all judgments, money judgments, are enforced through garnishment. And that's either, there are two forms of garnishment, and one is a wage garnishment, and the other is like a bank garnishment. So if people have funds in a bank account, they serve a writ of garnishment on the bank, and they freeze those monies to pay the judgment. Next slide, please. So this, is going to limit, garnishments basically through November 2020, possibly through February 1st, if extended. I would bet money, I'd bet $1,000 right now that it's going to be extended. So let's just call it through February 1st. And I think, I don't have the bill in front of me, but I think it went into effect immediately, probably in June. So more or less 7 or 8 months, where garns, and that's the legal term, garnishments, lawyers call them garns, they leave off the ishment. So are limited during this period. Next slide, please. So the key thing is, during this 8-month period, assuming it will be extended, the judgment creditor, that means you, the landlord, you got to tell the tenant, like, hey, you have a right to suspend this collection activity if you've been impacted by COVID. So let's go to the next slide, please. So if the tenant, and that's kind of funky, Matt, if you're on. So if we were going to need to fix that going forward. So basically, they issue, before they can issue a garnishment, they have to say, look, if you have a right to suspend us collecting from you through February 1st, if you've been impacted by COVID, and if the tenant responds in writing with the court and said, hey, I'm exercising my right, I've been impacted by COVID, then all collection activity is suspended until the limitation period expires. Next slide, please. So, and the other thing is the garnishment of depository accounts are limited to $4,000. So, if they had $10,000 in their bank account, you could only take $4,000 pursuant to a bank garnishment during this period. You'd think everybody would, all the tenants who have judgments, money judgments against them, after receiving the notice, would respond, hey, I've been affected by COVID, but I've been told by some of our associate, we work with the outside collection counsel on our program. They said that's not true. So you'd think they would, but that's kind of the deal. So the key point is on the next slide, is that this is going to significantly impact collections if you deploy a legal strategy to collect money during this period. Because I'd say, if you have, a flow of legal process going over, 3 or 4 years, you're probably receiving a significant portion of your monthly collection revenue through garnishment. And when that's put on hold for 8 months, it will drop off significantly. All right, if we don't have any questions about that, I'm going to move on to just kind of other issues. I call them EOs, executive orders, and other trends from the court. And maybe we can actually, I don't know, I got 10:08, so I don't know if we'll finish on time, but it looks like pretty close to it. So let's just start off with the next slide and talk about kind of the key issue here from the governor. Is the Colorado governor's orders executive order suspends the 10-day demand for rent and requires a 30-day demand for rent or possession. So everybody that's been around in the business knows it used to be a 3-day pay or quit, then it went to a 10-day pay or quit, and now the governor, I want to say starting in May, I think so. So let me just say, so May, 30 days to June, June, 30 days, and then maybe I got that wrong. Maybe, he signed his first one in June. So he's extended it 3 times now. So that probably is going to go on for a while. The issue is that, the legislature was talking about passing an eviction moratorium, which almost certainly would have been legally challenged in court. So I guess the governor's kind of trying to do what they couldn't get done down at the state capitol. It's hard to say whether the 30-day will continue going forward, but based on what we've seen before, there's no reason to believe that it won't continue. So I guess the next time frame is up sometime around September 12th or 13th. So we'll see if he extends it. There has been some discussion, a lot of discussion actually, on the Joint Legislative Advisory Committee that the legislature is going to try to make this requirement permanent. And to me, that's just really, as a landlord, that's really untenable, because if you think about it, say we're in August now, they don't, say there's no COVID and things are normal. How refreshing does that sound? But things are normal. And so they don't pay their rent on the 1st. They're late, if not paid by the 3rd. So you serve them on the 4th. Well, it's 30 days. So, the thing doesn't expire till like September 5th. Then you can't get into, court, say, for another 10 days. Now it's the 15th. So they file an answer. Now it's September 17th. And, say the sheriff takes another, 4 to 6 weeks, you're looking at, late October. So literally almost guaranteed 3 months to evict somebody if it goes to a 30-day. So, landlord, obviously, if they're living there the whole time, is going to be out 3 months of rent. I don't think that's sustainable. I mean, the 10-day was bad enough. So one of the things that people are going like, well, what's this teeny URL at the bottom? Well, we've been complying in anticipation of this legislative battle next year. We've been asking our clients to weigh in and to, set forth in writing why a 30-day demand for rent or possession would just be really damaging both to them personally and to the rental industry, you know, just basically how it would hurt them. So let's go to the next slide. The next thing people need to know about current trends are that courts are interpreting executive orders extremely liberally. And they are, I mean, literally looking for any reason not to evict. Tenants, they're making very friendly interpretations of the governor's order. So that, you know, they're making it very clear that, you know, they're taking steps to make it any step in their mind that they can take to prevent or extend a possible eviction they're taking. One thing people definitely need to know is your notices have to be right, because if they're not, you're just really going to be, you know, feeling a lot of pain, both monetarily and, you know, time-wise, because on your notices, the smallest error is they're just going to jump on it and use any technical error to, you know, throw out your case and make you start over. So, you know, with a 30-day notice, if you make an error on a notice, that literally is costing you another 45 days or another month and a half before you get into court. So it was like, you know, 30 to 40 days to begin with. Now you make a mistake, it's another 45 days. So, you know, that's like 80 days before you even get into court because of a mistake on a notice. Next slide. So there's a lot of talk, and I wanted to address this because I think that it's important. Is a lot of the, you know, tenant advocates have contended that, you know, 400,000, and this was like back in, you know, May and June, that 400,000 people would be evicted in the next 6 months. And the thing that they don't understand is that no one, not one person, not one landlord, not us, no one wants to see anyone evicted, okay? But at the same time, you know, contracts are contracts. Landlords have to pay their bills, they have to pay their employees, they have to pay property taxes, they have to pay the city, the feds, etc. And I just wanted to get this out there. This is pure propaganda, this 400,000 number, and I don't know how many people have seen this bandied about, but it's just really based on a lot of unrealistic assumptions about the economy and what unemployment rates. I'm not, you know, I don't want to be held for this, but I think that that prediction assumes like a 30% unemployment rate, which we're nowhere close to that right now. It also assumes that the economy is not going to be opened up. And let's just put this in a little bit of perspective. Is in, just say your average year, there's about 40,000 evictions in Colorado, okay, for the entire year, all right? So to evict 400,000 people, there would have to probably be about 200,000 evictions filed with the courts in the next 6 months. That's 5 times the amount of evictions in half a year that's ever been filed in an entire year. This is not logistically possible. You couldn't get near that number, even if there were that many people defaulting, which there's not. You couldn't get that number of evictions through the courts in 6 months. It takes an entire year to get 40,000 through. So it's simply not possible to get that number, 200,000 evictions, especially now that the availability of the courts has actually been ramped down a lot based on COVID restrictions. I bring this up because it really is a popular talking point in the press, and it's, again, it's propaganda, and I just am bringing it up because people need to push back with both the media and their elected officials. All right, let's have a quick review with the next slide of the CARES Act. Just remember that the CARES Act was signed into law by President Trump on March 27th, and it applies to covered properties. And The reason it is important is because the eviction moratorium under the CARES Act has expired, but the impact of the CARES Act is still affecting the default and eviction process, and may, and it may preview what additional federal action looks like. Everyone should know by now. I don't want to sound overly critical, so that's not my intent. But if you don't know what the CARES Act is by now, or whether you're a covered property, you're probably living in a cave. I think the address is, you can always, if you have questions, you can email the situation board, or you can also send an email to cares@thslawfirm.com if you're still kind of in the dark on that. So let's go to the next slide, please. If you recall that the CARES Act, and this is what I love when they say all these evictions, there was hardly any evictions. We didn't file a non-payment case for almost 3.5, 4 months. So just making that comment as an aside. But the eviction moratorium expired on July 25th, 2020. So now, unless something changes, that eviction moratorium for covered properties has expired. Let's go to the next slide, please. So so now that the eviction moratorium has expired, a couple takeaways. It's important to remember that if you are a covered property, you still can't impose any late fees that accrued during this period, including any after the fact. So the 120-day period was from March 27th to July 25th. So you can't impose any late fees during the moratorium period. But now that it's August, you can't go back, and that's what really after the fact and says, hey, well, the moratorium's expired, so now I'm going to impose on the ledger and try to collect late fees for April, May, June, and July. You can't do that. Those fees are gone, and so please do not try to impose them. President Trump did extend the eviction moratorium in the CARES Act, but here's the thing, is he did it via EO, executive order, and it really doesn't have any teeth. So it just says kind of like he would wish for it to be extended. So at this point, unless Congress acts or the judges act or somebody acts, or they just say, hey, we're going to rely on his order saying it was extended, which doesn't even really say it was extended, it doesn't really have any impact on evictions at this point. It's really more of a concept than anything else. That doesn't mean something will change. I mean, one of the key dates is right now is because the 30 days, the CARES Act required a 30-day notice after its expiration, and those 30 days actually all expired. If they were served on the 26th of July, they all expired yesterday. So we'll see, if anything happens. Obviously, with the election coming up, it's a very volatile political environment, so we'll have to see how that goes. Everybody's just kind of like in a waiting mode, but right now it's kind of all things are moving forward until further notice. So next slide, please. One of the things that we get asked a lot involving CARES is, what notice do we have to serve for non-payment of rent? Well, it was kind of complicated, but the executive order from Governor Polis makes it really simple. Is right now, everybody, whether you're covered or non-covered property, you have to serve a 30-day demand. So we'll just until further notice. So that just really kind of makes it really simple. And I guess when that goes away, then everybody will probably go back to a 10-day unless there's further action on covered properties covered by the CARES Act. Next slide, please. Okay, this is something that we definitely want to make sure everybody's aware of is you cannot, if you're a covered property and you're receiving mortgage forbearance, you cannot evict while your mortgage is in forbearance. So if you have a Freddie Mae or Fannie Mac mortgage on your multifamily property or your single family property and you're getting forbearance, you can't evict while in forbearance and 30 days after forbearance. And I think then you even need to serve a 30-day. So, you know, if you're in forbearance, it's probably 60 days down the road. If you have, after the forbearance period ends, if you have specific questions for us about that, please contact the situation desk. Next slide, please. Okay, this is something I want to make sure everybody knows is the eviction process and procedures have substantially changed. So if you're not familiar with the landscape, it could cost you significantly, both in terms of time and money. You know, we're constantly holding webinars to make sure everybody's up to speed on all of these changes, and there are numerous. We sent out a broadcast email to all of our clients covering the subject. If you did not receive that email, you can email Matt. That's Matt, M-A-T-T, at thslawfirm.com, and he will send you the kind of the summary of the of that to kind of get up to speed. One of the biggest new requirements is that CARES affidavits are required on all cases, especially on any eviction case filed in El Paso County. It's a very rapidly changing environment, so it's critical to pay attention and to make sure you keep up to speed because the requirements can change at any time. And as I pointed out earlier, notice errors are, you know, extremely costly when you're having a 30-day timeline. Next slide, please. One of the questions we get asked a lot in this environment is, should we accept partial payments? What are the consequences of accepting partial payments? Well, the consequence is really simple, is if you accept a partial payment, you have to start over. You know, prior to COVID, we always made recommendations on whether to accept partial payments based on the facts and circumstances of an individual case. That same analysis applies now. You know, frankly, if you don't want to start over, don't accept a you know, a partial payment, because you'd have to serve another 30-day demand and you're not going to get to a court date for several weeks. So like I said, if you take a partial payment, no, you're probably about 45 days out, you know, especially so if you're set for court, which is really hard to get into court now, but if you're set and you take a partial pay, the case gets dismissed and you're 45 days, you know, down the road. On the other hand, we're not saying not to accept any partial payments. In some cases, you know, it makes a lot of sense. You know, if guys, you know, 2 or 3 months behind, say it's $3,000 a month, and he's 3 months behind, and it was $9,000, and you know, he can pay $8,000. You know, in this environment, you know, that makes a lot of sense probably to take that, unless there's something else going on. The tenant may be damaging the property or disturbing other residents or some. You know, the key always, you know, pre-COVID and post-COVID was how much is owed and how much are they offering. I mean, if they're offering, you know, pennies on what's owed, then probably it's not a good idea to take it. If they're offering substantially all that's owed, you know, we're strongly recommending to our clients to take that. Another thing you need to know on partial payments, this was true pre-COVID, but it's really true post-COVID, is if a tenant makes a partial payment, you cannot hang on to the money, okay? You have to say, no, I'm not accepting the money, and return the money. And remember, we always say the best way to return the money is not to mail it or deliver it to the, to the resident as you write them a written, send them an email, or, probably it's best because you can prove you sent it and said, look, we've got your money. We're giving you written notification that we're not accepting your money. We're electing, to pursue, move forward with our possession action. We want possession and we're not accepting your money for security reasons. We don't want to put it in the mail. It's ready, willing, and able to be collected or returned to you. And you can do so by coming to the on-site office and get it. I guess you have to add PS, wear a mask in these days. Let's go to the next slide, please. There's a lot of programs out there dealing, with rental assistance. These are the common, questions that we get. We highly recommend accepting rental assistance, especially if it's the full amount. But know this, again, similar to a partial payment, you're not legally obligated to accept rental assistance if your demand is expired. You might say, hey, we'll accept the rental assistance at any time prior to the time the sheriff comes. One thing with rental assistance is you have to, be aware, which you are, but a lot of people don't factor it with the rental assistance program. You're aware of the fact that the balance is increasing because, people, more money might become due, or, they're charging daily fees, or a new late fee will accrue, or something along those lines. That doesn't really work that great with rental assistance, because these organizations, they want to know, like, okay, what's the payoff number? Oh, the payoff number is $4,237.82. Okay, that's how much we're committed for. So, but remember, it takes time to get this money. So you have to basically make it clear to them, that's the number you're willing to accept. And you have to realize it's not like that money can't be owed on the ledger, but you can't hold that little difference hostage and say, okay, now the whole deal's off if they don't pay that. You have to we recommend that you just put in writing, if they're assisting, what you're willing to accept from them to reinstate the tenant, and, say that's, other sums may become due and they're still owed, but we're willing to accept that to reinstate them. And I guess deal with that at that time. And, and it's always clear to, it's always best practice on rental assistance to put in writing what that number is that you're willing to accept. Let's go to the next slide, please. Okay, so they have the POP program came out. One of the things, because we're actually about to wrap up here, is you got to remember there's no such thing as free money. And common questions relate to the time of accepting funds and stopping the eviction. So there is no restriction on this program. And this is the POP program, and I'm at a loss. I'm sorry for payment something program. I don't know. I forgot. Maybe somebody can remember. I don't know if Pete's on. He can text me or send me something. But this is money that the state of Colorado received from the federal government under the CARES Act. And so it's really tightly regulated. And if you say, okay, fine, I'm going to accept the money and I'm on the program, you can't back out after you apply to the program. So once the application's in, you're committed. And then I think you need to look at, we have a memo on this that discuss the various risks. I'm not going to get all that into them. But the other thing, one of the things that you are signing up for on this program is that you will continue to serve a 30-day demand for rent or possession. And you are also agreeing to halt any eviction process if you're in that process. So, it just comes with strings. Know what the requirements are, know what the risks are. And, we're certainly encouraging clients to participate in it if they think that's a good option for them. So, That's what I have for everybody this morning.
It does look like a question came in.
Okay.
They get the Starbucks gift card. So exciting. So the question is, if payment is accepted after the 30-day demand period has ended, but before the FED hearing, does that jeopardize the proceedings?
It does. It does. You have to start all over. Yeah, that's what I talked about with the partial pay. So I think that's actually on the slide. So you know, I may not be on the slide, but that's really the consequences of accepting a partial pay is, you know, you go back to, it's like what, like Chutes and Ladders, where you get sent back to your start position. And I don't know if people have, oh, it's sorry, not Chutes and Ladders, sorry. I don't know if anybody's played that recently. My wife is very, very good at that when she's not being a hurricane. Yesterday she was a cat 4 because her name is Laura. So anywho, I think that's what I got for you this morning. Those are our web addresses and our COVID page, our specific COVID page. And so I guess we don't have any more questions. So I guess I'm gonna go ahead and wrap up and just say it was great to be with you this morning. And just remember that we're always available for our clients at any time to help you with whatever your needs are. Our mission is to serve our clients. So that's what I have.
Thank you so much, Mark. Thank you for taking the time to give that information. I know it was very helpful to everyone, so thank you so much.
Oh, you're welcome. You're welcome. So I guess I'll just sign off, and I guess we'll move along. And I guess Matt will, I don't know if Matt needs to contact you, but I think, you know, hopefully some more folks, because there is a lot of important information in there. And so hopefully people will be able to hear listen to it.
Yeah, I know we had a big group that said that this specific time they had a budget meeting, so they were scheduling a time early next week to watch it, like all together, the recording of it. So I think a lot of people are gonna watch the recording, and we had people on today too. So I appreciate you taking the time to do it for us.
Oh, you're welcome. All right, well, take care.
Have a good one, everyone.
All right, see you. Bye.
Bye.